So I have an important update in the Suppressor Freedom lawsuit, which aims to remove a state's ban on the purchase and possession of suppressors. So let's talk about this. But real quick before we jump into this video, if you think suppressor bans and regulations on the possession of suppressors is clearly a violation of the Second Amendment, go ahead and hit that like button and subscribe. Also, I want to thank one of the main supporters of this channel, which is Blackout Coffee. Blackout Coffee has amazing coffee and they are huge Second Amendment supporters. If you buy one of their dedicated roasts for FBC or GOA, some of those proceeds go directly to those organizations so they can file lawsuits which fight for our right to keep and bear arms. So check out Blackout Coffee, amazing coffee, and if you use the code ARMSCHOLAR, you can get 10% off of your order, and I will link them down below in the details section in the comment section. As I mentioned in the intro, in this video we'll be discussing two lawsuits which aim to remove a state ban on the purchase and possession of suppressors. The cases we'll be talking about in this video are called Morse v. Raoul and then also Anderson v. Raoul. Many of you may be familiar because we talked about this previously that both these cases have been consolidated and they deal with a federal lawsuit in a federal district court in Illinois, and the aim is to remove the state of Illinois' ban on the purchase and possession of suppressors. These lawsuits are important because although 42 states permit the ownership of suppressors, permit the purchase and ownership of suppressors, there are 9 jurisdictions within the US which don't. These lawsuits could be the first in the nation which find that a state's outright ban on NFA items like suppressors is clearly unconstitutional and violates the Second Amendment. However, in this case, the state of Illinois is trying to have the suppressor lawsuit completely thrown out, and they are arguing that suppressors are not arms, and therefore they are not protected by the Second Amendment, and that the plaintiff's claims fail, and the court should throw out the case. In the Anderson lawsuit, the plaintiff stated that the suppressors at issue in this case are bearable arms in common use for lawful purposes that law-abiding people possess by the millions. They are therefore neither dangerous nor unusual and cannot be banned. But now you have the state of Illinois who has filed a motion for judgment on the pleadings. The entire motion is based on the state's argument that the cases here should be thrown out because suppressors are not arms protected by the text of the Second Amendment. At their core, what they're arguing is that suppressors are not arms. For those not aware, a motion for judgment on the pleadings is a motion under the Federal Rules of Civil Procedure, and it's a 12C motion. This type of motion is used to attack the sufficiency of the opponent's pleadings. So essentially, it's an attack on the pleadings brought by the plaintiffs, and it's also a challenge to the underlying viability of the claims that are being brought, and this happens before a trial. The court in reviewing the motion is strictly limited to the contents of the party's pleadings and any documents that are attached to those pleadings. If a party wins the motion for a judgment on the pleadings, then the claims are dismissed by the court, and often it can also prevent a new lawsuit from being brought on those same type of claims. So the state of Illinois is trying to get this suppressor lawsuit thrown out and essentially prevent any future challenges to their suppressor ban. In this motion, the state of Illinois argues, plaintiffs raise a Second Amendment challenge to an Illinois law prohibiting the possession of silencers which are attached to firearms to reduce the noise of gunfire. But the Second Amendment protects only the right of the people to keep and bear arms. Silencers are not weapons. They are not used for self-defense, and they are not necessary to the effective use of a firearm. So they are not arms within the meaning of the constitutional text, and thus plaintiffs cannot prevail on their Second Amendment claim. So that is what the state of Illinois is arguing in this motion. They go on to argue that plaintiffs wish to possess silencers. So the question is, does the Second Amendment cover this conduct? Or more particularly, are silencers arms within the meaning of the constitutional text? Every court that addressed this issue has held silencers are not arms protected by the Second Amendment, and they say that that reason is simple. When the Second Amendment was adopted in the late 18th century, dictionaries defined arms to mean only weapons of offense or armor of defense, or anything a man wears for his defense or takes into his hands and useth in wrath to cast at or strike another. While an instrument need not have existed at the time of the founding to fall within the amendment's ambit, it still must fit the founding era definition of an arm. But a silencer is not itself used to cast at or strike another. It does not contain, feed, or project ammunition, and it does not serve any intrinsic self-defense purpose. And while some people find silencers useful, they are not so critical to firearm ownership that firearms cannot be used effectively without them. Silencers are therefore not arms within the original meaning of the constitutional text. They go on to argue that Silencers do not satisfy this definition of arms. A silencer is a firearm accessory. It is not a weapon in itself, nor is it armor of defense. So, that is the state's primary argument in this suppressor lawsuit in their motion for judgment on the pleadings, and they argue that suppressors cannot be considered an arm under the text of the Second Amendment because it's not an actual firearm, it's not an actual gun that shoots a projectile. They claim that only actual firearms can be considered arms and therefore protected by the text of the Second Amendment. They believe a suppressor is simply an accessory and cannot be protected. Now, two things on this point. First, the state of Illinois wants to discard all the other laws that we have on the books, including the NFA, a federal law, which defines and treats a suppressor as an actual firearm. Second, they want to gloss over the fact that the Second Amendment does not just protect arms, but it also protects conduct which is critical to your right to keep and bear arms. Like I mentioned, they also try to gloss over the express federal laws, which state that a suppressor is a firearm, and they simply respond to this by arguing that it makes no difference that some federal statute define the word firearm to include silencers. A statutory definition can, and often does, depart from a word's ordinary meaning. In this section, the state of Illinois is trying to dismiss the federal definition of a suppressor by saying that, well, yeah, the federal law calls it a firearm, but it's not really a firearm. And to that I say, well, why don't you tell that to the ATF, who regulates and treats these items as actual firearms? Then they go on to compare suppressors to Puerto Rico, which was a very strange comparison. They say just like the US calls Puerto Rico a state in some statutes and controls it and regulates it as a state, it's not really a state. We treat it as a state, but we're not going to actually claim that it's a state. They don't get representatives or anything like that. So again, it was very interesting, the argument that they're putting forward. They're saying like, yeah, we treat it as one thing when it's convenient for us, but it's not really what we try to regulate it as. They also take the position that suppressors are not necessary to the operation of a firearm, and they are not essential for self-defense. Illinois argues that for all these reasons, silencers are not arms within the original meaning of the Second Amendment, nor are they necessary to the effective use of such arms. Unlike range training and ammunition, silencers are not essential to the exercise of the core right to use arms for self-defense. The result remains the same, notwithstanding plaintiffs' allegations. They would use silencers to assist in target practice and self-defense. A firearm cannot be used for self-defense without ammunition, and it cannot effectively be used for self-defense without training and practice. The same is not true for a silencer. Firearms are effective with or without them. To this point, I would say that the Second Amendment does not protect only items which are necessary for the function of a firearm. If that was the controlling standard, then a rifle stock would not be protected, a red dot would not be protected, a vertical grip would not be protected, lights would not be protected, and even magazines used in something like an AR-15 would also not be protected, and a state could outright ban them. And that's really where they want to go. They want this leeway where they can ban anything that they want. The state also likes to make this blanket claim that suppressors are not used for self-defense. And I don't know about you, but I know plenty of people personally who own and have suppressors on their home defense rifles, on their home defense handguns, and other firearms expressly for the purpose of self-defense. Also, self-defense is not the only conduct protected by the Second Amendment. Self-defense is an important part of the Second Amendment, but it's not the only part of the Second Amendment. The Second Amendment also ensures that people have all the arms necessary to protect themselves against a tyrannical government, both foreign and domestic. It is not isolated to just self-defense. So again, this is a really interesting position that the state of Illinois is taking. I would say the NFA laws, which directly contradict this position, should be 100% sufficient to get this motion denied. But we will definitely have to keep our eyes on this to see how the judge ultimately deals with this. But if we get any more information on this case, I will let you all know. Also, if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.